Well, welcome clients and some family, friends, anyone who was invited to our latest educational webcast. Today, we're going to cover a timely topic, I think at any time. Many of us have been thinking more about it maybe during the recent pandemic. Estate planning revisited. And today we're going to get a little more into the basics of long-term care planning. Today, I've got with me a long-term friend and professional colleague, attorney Andy Hochberg. I've known for a number of years. And he will cover the topic of, again, estate planning and long-term care. So with that, attorney Andy.
All right, thanks, Dave. Hello, everyone. Hope everyone's doing well today. We're going to jump into some estate planning topics, and we'll talk about long-term care planning today, which is as Dave said, always relevant. I mean, death and taxes, we don't get away from it, right? I just want to give you a little background who I am. So I'm an attorney in Newton, Massachusetts. My practice focuses on estate planning and estate administration. So kind of planning things in advance before you pass away and kind of figuring out what things are going where and who's going to make sure that happens for you. And then when you pass away, making sure that, what you put in place gets implemented properly. And so today's agenda, I've kind of put together a few bullets that I want to hit on today. We're going to talk about estate planning. And estate planning, a lot of times people will hear that and say, that's really not for me. I am not uber wealthy. What do I need an estate plan? Can I just have a will? And a will is a document that's part of the estate plan. So think of the estate plan as kind of being the umbrella and the will being one component under the umbrella of these set of legal documents. So we'll talk about what a will is, when it's needed. We'll go actually talk about the components of a will, so you get a little better flavor of it. And another piece of an estate plan that is very important for depending on what we're trying to accomplish is a trust. And today we'll talk about trust a little bit, revocable versus irrevocable. I know a lot of people come to me with questions about, what is the difference and why would you ever have an irrevocable trust if you can't make any changes? Don't you want to make changes or at least have the ability to make changes? So we'll talk about trusts. We'll talk about estate taxes, which is not relevant for everyone, but if it is, it could be a significant financial impact. So we'll talk about what estate taxes are and how to manage that. And then as we said before, we'll get into long-term care planning. So some basics in long-term care planning. So let's kind of jump into the will. Okay. So what a will is, it's a legal document that you put together that dictates where your property goes and who's in charge of making sure that happens. All right. So when I talk about a will and property, we're talking about things and assets, whether it's a bank account, investment account, things that you own, could be the contents of your home. Right? So a will is going to control things that you own individually where there's no other co-owner or there's no beneficiary. All right. So it's not everything. A will does not control everything. What it does not control are assets that you own jointly or assets that you have a beneficiary designated for. All right. So let's give you kind of an example, give you some flavor here. So let's say I have a bank account and it's in my name only, no other name, and I have a will, and in the will, in the document, it says all of my assets, including that bank account, are to pass to my wife. All right, real simple. I pass away, I get hit by the bus. My wife now wants to go into the bank and close out that account. She won't be able to do that. Why not? Because I'm the only one who had a name on the account. So what the bank is going to do is going to say, well, my wife is not entitled to that account necessarily. The will has to be probated. And what that means is that will needs to it needs to be validated by the probate court. That process is, she would have to file the will with the court, ask the court to validate it. And if you see, sometimes you see in the newspaper, these these legal notices, so-and-so died, and if you have any claims against that person, now's your time to come forward. Well, that's all part of the probate process. That individual account that I had in my name is an account that's going to pass under my will. So if my will says it goes to my wife, it eventually goes to my wife, but she has to go through a process to get it to that point. Now, if I have, on the other hand, if I had her name on that account, so let's say it's a jointly held account. Jointly held account passes automatically to the surviving owner, right? Whether it's my wife or a child, a co-owned account like that passes automatically to the survivor. Now, take the example of the bank account. Both of our names are on the account. I get hit by the bus. My wife can walk into the bank the next day, literally, and she'd have immediate access to that. That's her account just as well as it is mine, no matter what my will says. So my will actually may say all of my assets are to pass to my kids. Well, my wife is still getting that bank account because it's jointly owned. Now, one thing is if you're not sure, if you're dealing with an estate or dealing with a bank account that for someone who passed away, and you're not sure whether it's going to pass under a will or not, if you go into the bank to close the account out or to take over the account, and the bank says, no, we need a probate order, we need a court order, or this is a buzz term, letters of testamentary. And all that means is it's the court's order that the will has been validated and that money is now accessible. So that's individual account versus a joint account. Another type of account, and this is very common for us who have retirement accounts, if you have a 401k, you have a beneficiary designated, right? So no matter what my will says, the will does not control the account where there's a beneficiary designated. Go back to my example. I have a 401k. I name my wife as the beneficiary on the 401k. My will leaves all of my assets to my kids. The beneficiary designation is going to control that. And so my wife will be able to take over the retirement account because she's the named beneficiary. Now, one thing before I jump off of beneficiary designation, move on to the next topic, I want to point out that it's very important to keep those beneficiary designations updated. Over the years, I've seen a number of times when clients will come in and they will have a beneficiary named, but the beneficiary since passed away. And what happens there is the money doesn't go to the state. And a lot of people think it just disappears. It doesn't. It's still your money, but it has to go through probate. So it's becomes more complicated. And for retirement accounts, there are some negative tax implications if you do not have an updated beneficiary designation. So talked about the will, leaving assets that pass under the will if they're not jointly held and there's no beneficiary designation. The other component of a will, very important, is naming an executor. The executor is the person, or personal representative is a more common term now, but it's the same, those terms are interchangeable. But this person is the person I am putting in charge of my business when I'm not here anymore. It's the person who's going to implement the terms of the will. Okay, so if I decide I want all of my assets to pass to my kids, and maybe I'm going to put my wife in charge as the executor, I'm giving her the responsibility to make sure my kids receive my assets under the will. So what does an executor do? The executor is, as I'm kind of alluding to, controlling the probate process. That's the person who actually has to take the will to the court, have it go through that validation process, and ultimately have the appointment issued by the court, and then go back into the bank, for example, and close out the account. The executor is also responsible for implementing the dispositive provisions that I put in my will. So if I want all of my assets in my will to go to my children, my executor is going to be responsible for making sure that happens. That's his or her responsibility. The executor is also settling any claims. If I have any, let's say I have final medical bills that need to be settled up, not covered by insurance, those are issues that the executor is dealing with. And then finally, I put a bullet here that the executor may be responsible for losses of the estate. That's not really referring to losses as in the executor put the money in the stock market and the market crashed that day. That's not necessarily the executor's fault or responsibility, but the executor is responsible for making sure that the money is not misappropriated or directed in the wrong way. And the executor could be responsible if that does in fact happen. So that's the executor's job. One other piece, and actually one other person that you want to address in a will, and this is not going to be for everyone, but it will be if you have small children, minor children, is naming a guardian. Okay, so in the will, we have directed where the assets pass. We have named an executor, and if I have young children, I want to name a guardian. Now, the guardian is the person who's responsible for care and custody of the kids, not necessarily the money side of things, but taking, as a parental type control over the children until they're 18. So once the kids turn 18, that guardianship provision becomes moot. Or if I've passed away and the kids are still minors and they are subject to the control of the guardianship terminates. It ends when the kids turn 18. One other question that is oftentimes raised is that I'm naming an executor under the will. Should I name the same person to serve as the guardian, or should I separate those two jobs? And my advice initially is usually it's better to have one person serve in both capacities because it's just less opportunity for things to fall through the cracks. However, if you're in a situation where you have someone who would be great with the kids, really has the parental, skills that you're looking for, then you would want to name that person as a guardian, but maybe the person is not so good with money or not comfortable dealing with money. That's in a situation where you do want to, separate the two responsibilities, executor here and guardian here. The next document is part of the estate plan that we'll want to put in place. There are actually two documents that are similar, and I'll cover those one at a time. One's a healthcare proxy, and the other is a durable power of attorney. So a durable power of attorney is for financial decisions if I become incapacitated. So I want to make sure that someone has the authority to make decisions for me if I'm incapacitated. And kind of put things in perspective here. Let's say I have a retirement account. My wife is the beneficiary. I become incapacitated. Even though I'm alive but incapacitated, even though my wife is the beneficiary, neither of us will be able to do anything with that account. I won't be able to because I'm incapacitated. I don't have my faculty. My wife won't be able to because she's not on the account. The account, when it's a retirement account, is individually owned. So if I have a power of attorney and give her the authority to deal with the account, that's key. I want to do that. And that means that if I'm incapacitated and we collectively need to take money out to pay for my care, or maybe I want to make some changes in the investment makeup within the account, these are things that she'll be able to do under the power of attorney. Now, a power of attorney kind of comes in two flavors. We have an immediate power of attorney, which is not so common, but it does happen. And then we have a springing power of attorney, which is by far more common. And the difference between the two is immediate power of attorney is as soon as I sign it, it's effective. I don't have to be incapacitated. A springing power of attorney kind of kicks into being if and when I become incapacitated. So the fact that I sign it today, it really doesn't do anything. But if I become incapacitated next week, now it becomes effective. So springing versus an immediate power of attorney. The next document I want to talk about is a healthcare proxy. So a healthcare proxy is similar to a power of attorney, but it's in this case, we're only dealing with not financial decisions, we're dealing with healthcare or any medical decisions. So a healthcare proxy is a document where I appoint a healthcare agent, someone to make decisions for me if I can't communicate with my physician. So it's actually triggered a little differently than the power of attorney. Power of attorney, typically, I need a letter from a doctor stating that I'm incapacitated. A healthcare proxy is triggered by my inability to communicate with my doctor. So let's say I have all my faculties, but I don't have a voice. I'm thinking, but I can't communicate. My healthcare proxy is then triggered by that. Now, a healthcare proxy a lot of times will have what we call a living will. And the living will is a part of the healthcare proxy. Sometimes attorneys will draft it as a separate document, but the intent here is that it is dealing with end-of-life decisions. And it simply states, or should state, that if I get to a point where I am determined to be in a permanent and persistent vegetative state, that I do not want to be kept alive by heroic measures, kind of a care and comfort only order. Similar, so it is very important to have, in my opinion, have not only put this in writing and put this in place, but if you're putting a healthcare proxy in place, have a discussion with your healthcare agent beyond the four corners of the document, beyond the language that's put it down, kind of what your feelings are. So in the healthcare proxy, if the healthcare proxy is in a position to implement your decision or your wishes, they've got the knowledge heard firsthand from you. Okay, so that's three key pieces to the estate plan: the will, the durable power of attorney, and the healthcare proxy. The next document is not a part of everyone's estate plan, but probably should be part of most people's estate plan, and that is a trust. So a trust in some regards is similar to the will, as it dictates where your assets go when you pass away. And a trust has three jobs that need to be identified here. Three positions need to be identified. The first is the grantor. That's the person who's setting the trust up. If it's my money and I'm setting the trust up, I'm the grantor. The second position is the trustee. That's the person who's managing the trust, managing the assets in the trust. And the third is the beneficiary. That's the person for whom the assets are being managed. So in a very common situation, I will set up a trust that I can revoke. I can completely make any change I want at any time, revocable, where I'm the grantor, I'm the trustee, and at least for now, I'm the beneficiary. And when I set that up, I'm not giving up control over my assets, but when I pass away, my successor trustee, someone I name, will now step in and manage the assets for the beneficiaries in accordance with the terms that I want. So I'm going to put down rules for the trustee. Distribute money at a certain age, don't distribute to my nephew, whatever provisions I want to put in there, I have the ability to do that. Why set up a trust? If I have a will, do I need a trust? Well, a trust kind of runs parallel to the will. And the most common reason people set up revocable trusts is to avoid probate. So that whole process where my wife went into the bank and they said, no, you need letters of testamentary, and she had to go back and she had to go to the court and file documents, and she waited for literally months to get the court to act on her petition. All of that can be avoided if I set up a trust and I have my assets in my trust kind of in communication. In other words, I need to set the trust up and I have to retitle my bank account in the name of the trust. So when the trust owns the bank account, my successor trustee will have immediate access to the account. So avoiding probate is definitely number one reason why people set trusts up. The other is reducing or eliminating estate taxes. So I'll briefly talk about estate taxes in a minute, but for now, if I'm working with a couple and I'm trying to reduce their estate tax liability, we'll oftentimes use trust to do that, to take advantage of estate tax exemptions. A trust also gives me the ability to protect assets from creditors, mostly creditors of my beneficiaries. Okay, so let's kind of go through the example. I am setting up a trust and I'm leaving my assets to my daughter, for example. And I'm concerned about her husband, never liked the guy, and I don't trust him. So I'm not leaving her the assets. I'm leaving it to her in trust so that if her marriage works out the way I predict that it's not going to work out, he won't be able to access those assets. So I have an ability to, through my trust, protect the assets for my child or any beneficiary. I'm also using the trust to maintain privacy or retain privacy. So when I go through if my wife had to go through the probate process, that's a public process, and she's going to have to list all of my probate assets. On the other hand, if everything is dealt with in a trust, there's no publication of that information. So there's privacy. I'm also able to exercise greater control of my assets. So for example, let's say I want to leave assets to my kids and they're too young. They're not minors, but they're too young, in my opinion, to manage their inheritance in a lump sum. So I'm going to say, okay, here's the inheritance. It's going to sit in a trust. The trustee can make distributions, but the kids don't get to manage it individually. So I've got some restrictions in place. Another reason why people set up trusts, and I'll get to this in a few minutes, is for Medicaid or long-term care planning. And that is a different type of trust. That's not a revocable trust. That's an irrevocable trust. And then finally, a lot of times I'll meet with clients and they have kids who are special needs. They're receiving government benefits that are asset dependent. In other words, if they have too much money, the government program stops. In that case, I can set up a special needs trust that will support them, but not supplant and replace the government programs. So real quickly, jumping through this, estate taxes, we have the estate tax is a tax that's based on the value of your assets that you leave when you die. Typically, most often, when you leave assets to a spouse, that's not taxable. It is only when the assets pass to the next generation. In Massachusetts, we have a $1 million threshold that once you hit that, everything is taxable. On the federal side, there's an estate tax, but there's a $12 million threshold. Very high threshold, but also a very high rate. It's 40%. Massachusetts, the tax rate fluctuates between 1% and 16%. So let me get on to Medicaid planning. And that's a topic that I talk to a lot of clients about. And this is dealing with what happens if you go into a nursing home. How do you protect your assets? We all know, either firsthand or just reading about it or just knowing that going into, having to move into a nursing home is a very expensive proposition, thousands of dollars a month. There is a program, Medicaid, that pays for that type of care. The government program, Medicaid, will pay for someone's care as long as they have less than $2,000 or less. You have more than $2,000, the government is not writing the check. You're on your own, your private pay. Now, it used to be years ago that you could look at your assets and transfer everything you have to the kids, saving $2,000, and then applying for Medicaid. The rule now is essentially there's a 5-year look back or 5-year penalty. So if I make that type of transfer, if I get rid of all of my assets, give everything away, leaving myself with $2,000, that's not going to work until 5 years passes by the time, from the time I made the transfer. So some of the planning options that we look at is making that gift today to start the 5-year clock run. If I make a gift today, in 5 years, I'm potentially eligible for Medicaid. Now, I can also do something like protect the house. And by that, I mean the house is treated uniquely in Medicaid. So when the government looks at your assets to see if you have more than $2,000, if I'm married and my spouse is still in the house is protected. It's not included as one of those assets. So I go into a nursing home. My wife is still living in the house. We call her the community spouse. She's still living in the house. The house is not counted against me as an asset, so I potentially could qualify for Medicaid. Okay, so the last area that we focus on in Medicaid planning is setting up a Medicaid qualifying trust. 3 key rules here. One is, unlike the trust that we had been talking about before, this trust has to be irrevocable, meaning once the ink dries, you cannot make any changes. So I have to set it up now, and this is key too, The only thing that I can take out of the trust is the income. All right, so give me an example. I have $200,000. I want to set up a Medicaid trust. I'm going to put, think about it, I'm going to put $198,000 in the Medicaid trust because I can keep $2,000. When I put the $198,000 in the Medicaid trust, I cannot touch that money. That money can be invested. Let's say I put it in the bank, and the bank, whatever they charge, whether they give you interest credit, you're earning, let's say, $3,000 for the year. I can take out the $3,000 from the trust, but I cannot touch the $198,000. So this is really where a lot of people look at this and say, the math doesn't work. If I put all my assets in the trust today, what am I going to live on for the next 5 years? So it's a process that you have to go through to see if this is going to work for you economically, because this 5-year clock is going to kick in. So again, the trust has to be irrevocable. I am only entitled to the income earned by the trust assets, and the trust has to be kind of old and cold for 5 years before it's even going to work. So it's not, this Medicaid trust, when it works great, but it's not for every situation. Let's kind of recap here. So I talked about estate planning, the key elements of estate plan: a will, a durable power of attorney, healthcare proxy, a trust. Mostly in estate planning, it's a revocable trust, and not for everyone, but most people should at least consider a trust. And then Medicaid planning, a different type of trust is often used. I guess before I jump off the Medicaid planning, a lot of times I'll sit with clients and we'll go through this trust analysis. And at the end of the conversation, it just doesn't work. It doesn't make sense for where they are, what they're trying to accomplish. In that case, a lot of times people will turn to insurance, long-term care insurance or life insurance with some sort of long-term care component. And from my perspective, I always say that that's a very good option. It's an affordability issue, though. If it's affordable, if the budget can handle it, it's a good option to explore for sure. Just to finally, I want to recap. I've got a slide here with some resources if you want some more information. Certainly, you can reach out to me. You can reach me through Dave, or you can hit up one of these resources and do some research on yourself. And then just want to point out that I'm an estate planning attorney and my practice is in Massachusetts. We do have attorneys in the office who practice in New Hampshire and Maine. And estate planning is really state specific. So the general rules are going to be transferable from state to state, but there are definitely certain rules that only apply or that apply uniquely to a particular state. And with that, Dave, I'm going to turn it back to you.
And thank you all. Enjoy the weekend.